I can see how useful it is going to prove as a tool. Now, today I'm going to speak a little bit about a European regional complaint system, effectively. I'm going to focus on the European Social Charter system. Now, you will see immediately that my slides are very, very text heavy. And this is not because I want to spend the next 15, 20 minutes reading through every word. It's actually so that they can serve as a resource after the event for people attending today. So don't panic when you see all the text. But so what is the European Social Charter system? So, I mean, the way it's always presented and the way it's described is as completing the picture of human rights protection in Europe. Okay, it's a Council of Europe treaty. It is, described as the sister instrument to the European Convention on Human Rights, but, and this will not be a surprise to anyone who is listening, it is of significantly lower status in practice. And by that I mean it is less well known, the system is less well resourced, and a third way in which the system is different to that of the European Court, European Convention system, is that it is monitored, instead of being monitored by the European Court of Human Rights and the Council of Europe Committee of Ministers, rather the implementation of the European Social Charter is monitored by a body of independent experts called the European Committee of Social Rights, and I am a member of that committee. And when you look at that body, it is probably easier to understand that body and the way it works if you think of it as being like a UN treaty body, like the UN committee, which Sonia is going to speak about later, rather than a court in the domestic or in the sense of the European Court of Human Rights, okay? And I'll talk a little bit more about that, but really it's easiest to think of it in that sense. This is a regional complaints or communications mechanism rather than a court as such. So what does the committee do? Well, we have two main functions. The first function is that we look at state reports, and that we break up the different elements of the charter into 4 different areas, and we look at one set of rights every year. So states report every year on a different set of rights. So for instance, the last time we looked at the right to housing under the charter was in 2019. And we released our conclusions, which are our soft law findings on state performance, earlier this year in 2020. And there'll be a link to them from the slides and on the committee's website. And we will be looking at states' efforts to give effect to the right to adequate housing, again, in 2023. So this is useful for housing rights advocates because, first of all, you have recent findings that can be used for advocacy at the domestic level. They're from 2019. And second of all, it also means there's a long time to prepare input into the next monitoring cycle of the committee looking at housing. But today, what I really want to focus on is the question of collective complaints. And this is our complaint system. So, and I'll come back to it in a minute. And this is the way in which a complaint can be brought about a state's failure to adequately secure rights under the European Social Charter. Now, a little bit of background, because I'm conscious that for many who are not familiar with the Social Charter system, it can come across as being quite complex, when in fact, once you've done a little bit of work into it, it actually isn't very complex at all. I mean, there's a fairly clear structure to it, and it's fairly easy to understand, but it takes a little bit of research, and many people haven't been trained in the European Social Charter, whether at university or in practice. So it's important to try to get on top of this now if you're interested in using it. So first of all, there's 2 instruments. First of all, there's the 1961 Charter, which is largely concerned with rights focused on workers or employers, so right to safe and healthy working conditions. It's from 1961, so there's some rather dated language about protecting pregnant women for particular kinds of labour. There are some social rights provisions, the right to economic, legal and social protection of the family, for instance. So that's the 61 Charter. And as I say, unsurprisingly, it's very much a creature of its time. It's quite old-fashioned the way it's phrased to some degree, as indeed is the European Convention, which is of course even older. But then in 1996, following a period where basically very little was happening with the Charter, there was very little attention being paid to the Charter system, there was a decision made that something needed to be done, right? Either the Charter system was going to be reinvigorated, revitalized, or it was going to have to go, effectively. And so what we see in 1996 is we see something, the revised European Social Charter. And this is a much more up-to-date document. It introduced a much wider range of social rights, unsurprisingly, excuse me, it includes, right, it builds on, for instance, rights to social security and social assistance, to include things like the right of elderly persons to social protection, the right to protection against poverty and social exclusion. And this is the only regional or international human rights treaty where we find such a provision, this explicit right to protection against poverty and social exclusion. And the committee is the only regional or international complaints body or court that has looked at this right in its case law. Very importantly for today, the revised social charter includes the right to housing. Okay, now there are elements of the right to housing covered in the 61 Charter, but they are also included in a very specific provision that we'll look at in a minute, Article 31. And then again, also in contrast to, say, most of the UN conventions and the regional human rights conventions, bar the UN Convention on the Rights of Peoples with Disabilities, we see a very detailed right of disabled persons to independence, social integration and participation in the life of the community, and we see a non-discrimination clause. So all of these, there's a very wide range of social rights protected. So let's talk about the right to housing. Okay, so first of all, I think it's important to note that with this, if we go back, when we look at the social charter, initially 43 out of 47 Council of Europe member states signed up to the 61 Charter. Okay, so 43 out of 47, which means there were 4 that never signed up. Then when we have the revised Charter, 34 of those 43 signed up to the revised Charter. So that means now that there are 9 countries that are still bound by the earlier Charter, and there are 34 countries that are bound by the revised European Social Charter, the 1996 instrument. And where a country has signed up to the 96 revised Charter, that replaces that instrument replaces the 1961 Charter for the purposes of the country's reporting and for the purposes of complaints that can be brought against the country. Okay, and I'll come back to that later. So, right to housing. We have key provisions. We have Article 16 of the original 61 Charter and the revised Charter. And this outlines the right of the family to social, legal and economic protection. And crucially, it includes the provision of family housing. Okay, so it's family housing, not housing generally, but family housing. And that provision has been accepted. So states have there's an a la carte system by which states choose to select the elements of the Charter that they'll be bound by. And this provision on the right of the family to social, legal and economic protection, including family housing, has been selected and is binding on all 61 Charter and 1996 revised Charter parties, bar the ones that you can see in front of you. And you can see it's a very small number of countries that don't include, that aren't bound by Article 16. So there's an awful lot of information from the committee about what Article 16 means in different national contexts, which is very useful for advocacy. Then we have Article 31 of the revised Charter, where you can see this is 1996. We've had the General Comment 4 of the UN Committee on Economic, Social and Cultural Rights. We've had the work of some of the UN Special Rapporteurs. And what we see is a very developed right to housing. And you can see the wording in front of you. It says, with a view to ensuring the effective exercise of the right to housing, the parties undertake to take measures designed to promote access to housing of an adequate standard. So adequate standard, we'll come back to that. To prevent and reduce homelessness with a view to its gradual elimination. And as Maria said, we've seen homelessness has been stopped in the COVID context in many places, but will we in fact see elimination, or is this just a short-term solution to homelessness? And third, to make the price of housing accessible to those without adequate resources. And of course, those of us who live in Europe are very aware of affordability of housing being a huge issue, particularly following the crises of the late 2000s. And we still have huge issues with access to housing. So negatively, in terms of advocacy, only 14 states have accepted Article 31 in full or in part. So some of them have only selected.
Hi, I think we've lost you, Aoife. Can you hear me? Hello? Okay, apparently we've lost Aoife Nolan. It's probably a question of the connection. Maybe let me just check with her via phone to see if she can come back or she can rejoin us. Otherwise, maybe we can continue with. Okay, so her internet got cut. So let's give her a minute and see if she can get back to us. Otherwise, maybe we can continue also with Sonia. Just a second. Meanwhile, just to say, this is how the handbook looks like, and there are several parts. One is about the United Nations, one is about the Council of Europe. So what Aoife was telling us about, especially the European Social Charter, and there's also a part about the European Union. So we are not going to speak about the European Union or the role of the Court of Justice or the EU Charter of Fundamental Rights, but these are all part of the different tools that we have available. And I think Aoife is back with us. Hi, Aoife.
I'm very sorry about that.
Okay.
We have builders in our area and the internet sometimes goes.
No problem.
Anyway, let me continue. May I just check, am I speaking at the right speed for people, or have there been comments about that? I just want to check if it's too fast.
No,
Maria, everything's fine? Perfect.
No,
great.
No problems with that.
Brilliant. Right, listen, let's continue, and forgive my apologies. So, we were talking through the various states now, so to come, and information available on the committee's webpage. And so in the committee's digest and in their conclusions and decisions. So if you're interested in this area, click on this link. Go and look at what the committee has said about the right to housing under Article 16 and 31. And in our actual case law, with our collective complaints, we've had a series of complaints that deal with issues like adequate housing. What is adequate housing? I mean, everyone thinks they know what it means, but obviously if you're lawyers or you're trying to get legal protection for a right to housing, you need to be forced evictions and legal procedural protections of housing rights we've looked at frequently. Roma, the rights of travelers, gens de voyage, several cases taken with regard, collective complaints taken with regards to the rights of these groups, dealing with things like living conditions and social segregation, whether de jure or de facto. Measures taken to address homelessness, the position of children in an irregular migration situation, the question of affordable housing we've looked at in our conclusions, and we have a specific test for whether housing is affordable in terms of income, family income. So there's really an awful lot to work with. And because our jurisprudence is Europe focused, it is sometimes the standards may be more transferable for those advocating looking at different countries within the European region than drawing on for instance, the concluding observations of the UN committee might be, where you have such a divergence in experience when it comes to rights implementation and rights enjoyment. So, but as I say, the digest is the place to go. And the key thing to note is that, as I said, the vast majority of states have accepted 16. Only 14 states have accepted 31. But there are very significant areas of overlap between Article 16 and 31. And that includes notion of adequate housing and forced eviction. Okay, so the fact that the state you're based in hasn't accepted 31 doesn't mean there isn't an awful lot that you can do with the social charter to argue for improved housing, housing measures, whether law, policy, or budget making. So finally, I'm going to do very quick comments with regards to the collective complaint system. Now, the first thing to note is that this is not an individual or a state complaints mechanism, right? And you see, for instance, an individual complaint system in the system, you see it, you can see in the UN level context, or you can see, the European Court of Human Rights is very much focused on, the individual. This is very much about looking at a systemic issue that is raised by a group that has a serious interest in, securing the protection of the rights in question in the country in question. So who can bring complaints? So you have, first of all, you have a whole range of trade union organizations. Then you have, if you go down to the third bullet point, you have representative of employers organizations and trade unions in the country concerned. So there's a bit of our case laws about what is a representative employers organization or trade union, and there's some case law around that. But generally there's a very wide range of trade unions and employers organizations that can bring decisions to the committee. And what's important to note is it's the committee that decides if the trade union is representative, not the country itself. We have our own criteria. Then there is, if you look at the second bullet point, and I think this will be relevant to many listening today, is that the other group that can bring complaints are NGOs that have consultative status with the Council of Europe. And there's a list drawn up for this purpose by the governmental committee. And the NGOs, it's not just about having consultative status, the NGO also has to have recognized competence in the matters relating to the subject of the complaint. Okay. And of course, some of our decisions around admissibility focus on whether NGOs in question have in fact competence in the area they're trying to bring a complaint about. So you'd need to look at that if you were bringing work. But you can see, if you look at who has brought complaints, there's a very wide range of different civil society organizations, domestic, but particularly international, and trade unions. There's also national non-governmental organizations selectly expressed by contracting parties. So but the key thing there is to recognize that an individual can't bring a complaint. It has to be an organization, and it has to be an organization that meets certain specific requirements. And what can be complained about? So I've mentioned already that when you sign up to the European Social Charter, or you sign up to the revised Charter, There's a minimum number of provisions, so articles or sections of articles that you have to sign up to. Otherwise, in order to be a party to the charter, okay? But that obviously is different to, say, the UN system, where to be a party to the International Covenant on Economic, Social and Cultural Rights, you sign up to the treaty and you're bound by all parts of that treaty. That isn't how it works for the European Social Charter system. And if you're bringing a collective complaint, you must show that your complaint has to be based on part of the charter that has been selected by the country you are bringing the complaint against. Okay, and that is tricky, because you could have a brilliant case that will be superb. You've looked at the European Committee's work and it looks fantastic, and of course it ties in well with what you're doing, but actually the relevant Article 31 or Article 16 hasn't been selected. So that should be your first thing to check. The other major challenge is that only 15 states have ratified the complaints protocol at the moment, okay? But again, if you look at those states, the small number of states has not meant that there isn't a very significant amount of solid jurisprudence that can be used. And also, frankly, when you see the jurisprudence, you can also see the arguments in advocating for your country to, if it isn't a party to the additional protocol, to sign up to it. Okay, so 15 states have signed up. I'm going to finish, because I was initially a strategic litigator myself. Some quick thoughts. What are the good things about the European Social Charter system? Okay, strong direct protection of the right to housing. A systemic approach to systemic issues. You're not trying to twist an individual case to solve a bigger problem. Okay? There's historically a quick turnaround in complaints. It's about 2 years at the moment, 18 months to 2 years. As we've got busier, we sit 7 weeks a year, and we've been hit by COVID too, things slow down. But it's much faster than the court and much faster than many other regional bodies or international bodies. We try to prioritize urgent issues. You'll have seen last year that earlier this year, we prioritized immediate measures focused on the position of children in the Western Aegean Islands in Greece, children, asylum seekers and migrant children. Very importantly, the social charter system is growing in profile, and notably, more and more often, domestic courts are actually referring to it. They mightn't follow the charter, they mightn't follow the committee's work, but they are aware of it in a way that they weren't before. But there are problems too, and these are my last thoughts. If you're a strategic litigator, you don't get a binding judgment. Okay, it's not like the European Court of Human Rights. You don't get an individual remedy. We don't grant compensation. We have, in the past, we've tried to reimburse legal costs, but the committee administers, which refused to approve that. There is an ongoing failure to ratify the collective complaints protocol in particular. And finally, there's the issue of non-implementation. And our admissibility criteria is incredibly relaxed to other systems. No exhaustion of domestic remedies required, no time limit. But the trouble is, we can even hear repeat complaints if situations haven't been sorted out. But of course, we don't want to be hearing repeat complaints. We want things to be fixed. So listen, I'll leave it there. Apologies again for the interruption, and I look forward to questions after Sonia's.
Thank you, Aoife. Hi. So sorry about that. I mean, time limits. It's always difficult, especially when there's so much to say. So, as Aoife has mentioned, FEANTSA has submitted in the past several collective complaints in the course of the years, and we firmly believe that it's a very important system, and we recently launched one in February, but we know that things have slowed down with the COVID-19 crisis. So let's hear Sonia Olea now talking about the role of the Committee on Economic, Social and Cultural Rights and the experience of Caritas using this avenue. Okay, thank you.
Thank you so much, Maria Jose. Like always, your job and your passion, and it's a privilege another time to be with you here. And thank you so much, Aoife. And we will see if Spain someday sign the REEC and the protocol. But now we have the Human Rights International system. I hope you can see the presentation. Okay. And I am speaking about the decision of the United Nations Committee on Economic, Social and Cultural Rights, specifically the protection, guarantee and defense of the human right to adequate housing. All of you can find my presentation in the web of Housing Rights Watch. In this moment, you can find in PDF. Caritas started to work with the United Nations tools in 2015. At the beginning, we started to work with a special procedure, specifically with Liliana Farha. We started to work also with Maria Jose, also with FEANTSA in the Habitat 3 process, and then we started to work also with the treaty bodies, with the UPR, Universal Periodic Review, and with the Human Rights Council, and of course, with the Office of the High Commissioner for Human Rights in Geneva. For Caritas, has been very important to work with all the tools together and with coordination with all the tools, because it's not easy in Geneva. Sometimes you are working with technicians from the High Commissioner with a special procedure, and they are working in one way, and the Economic, Social and Cultural Rights Committee is working in another way, and sometimes has been very important to have meetings with all of them together. And for us, at the beginning, was very important to work with FEANTSA also, and then we started to work with others, NGOs and others entities, human rights entities in Spain. International tools to claim for human rights to decent and adequate housing are 3. International Covenant, ESDRC, as you know, and with 2 ways, the periodic report every 4 years, and of course the optional protocol. Other important tool is the UPR. For us, was very important to present reports about housing and about another human rights in the UPR Spain 2015, and the last July, the UPR Spain 2020. And of course, the special procedure, with the special rapporteur on adequate housing as a component on the right to an adequate standard of living and on the right to non-discrimination in this context. As you know, we have different ways: the reports, the annual reports, the country reports, and of course, the emergency procedure if you need to use that. The right to housing is contained in the International Covenant of Economic, Social and Cultural Rights and developed in the General Observation of the Committee. The Article 11 from the ESDR Covenant speak about the adequate standard of living. As you know, is the same. Is very similar that the Article 25 of the International Human Rights Covenant. In the General Comment number 4, you can find what are the conditions you need to be in front of adequate house, and speak about what is an adequate house, the relationship with other human rights, of course, the duties for states. And in the General Comment number 7, it's about the duty to avoid forced eviction without adequate protection for the cases in Spain, and for the actual situation. Yesterday, I has been in a eviction in a city in the north of Spain, in Huesca, with a mother with two little boys. And finally, we have the good news that the vision was in suspension for the moment. We don't know for how many time. Since 2013, we have the optional protocol. And in the Article 2, you can find the communication system. And in the Article 5, you can find the process of the interim measures. As all the international system of the human rights and the American system of the human rights, you know that you need to be in exceptional circumstances to avoid possible irreparable damage to the victim. This is the point. And it's very important to have documentation to prove this situation. Well, and at the moment, there are 4 decisions against Spain, and for the violation of the human right to an adequate housing. The first decision was about a foreclosure without personal notification. The second decision was about a rental eviction in Madrid with a family with kids, and the family was in a terrible situation without a residential alternative. The third decision was very important because it was about an occupied house and a squatter family, and without, of course, a residential alternative in Madrid. All of the decision was about cases in Madrid, and now we have the fourth decision. And also it's about a rental eviction in Madrid without an alternative accommodation. Now there are 135 pending cases about, all of them, adequate housing and against Spain. It's incredible, but now you can find in the webpage of the committee, you can find 138 pending cases about all of the rights of the covenant, and 135 pending case, and 135th of the pending case are about housing and against Spain. Only another one about housing from Belgium, and another one from Argentina, another one from France about other ICESCR rights. Okay. Since 2017, and started to work together entities and lawyers from law firms, human rights NGOs, social action, social platform, and victims. We work in legal analysis, advocacy, communication strategy, training and awareness, and of course participation in other networks. Of course, in the ICESCR platform in Spain, and of course in the ICESCR network around international network. I know I have only 5 or 7 minutes. I will try to speak short. So the point is, as you all know, the normal procedure in the international human rights level is, first of all, to finish the internal process. But in the case of Spain, the committee knows perfectly well in Spain it's not possible to go to the Constitutional Court because the housing is not a human right in Spain, it's not a fundamental right in Spain. So it's clear that we have not an effective domestic remedy. So and we can go directly to the committee and in the two possible process, with the communication and with the interim measures. Very important, if you are thinking in the future, if your country sent the optional protocol, there are 4 essential cases, and you need documentation about these 4 essential cases to think to go to the committee. First of all, not having a decent and adequate alternative housing, have applied and for public housing and prove this point and the rest of the point. Social report that establish the situation of vulnerability of the person, of the family, social and economic vulnerability, and having previously alleged the violation of the human right to housing and that the court has rejected it. Request for suspension of the eviction. The interim measure, here you have the link, and because there are guidelines in the web page of the committee. When you have the documentation, you send in the communication and request for interim measure if applicable, because maybe you only need to send in the communication. Then the next steps that will be the admission and granting, and notification to the applicant, and the other side, notification for the permanent mission in Geneva from your country, in our case of Spain. The permanent mission of Spain send the information to Ministry of Justice, and the Ministry of Justice send information to the Ministry of Urban Agenda, because we are speaking about an alternative housing. And also at the same time, the Ministry of Justice sent the concession of the interim measure to the court, to the tribunal, to the judge for they consider how to do. Sometimes the eviction is suspended, but the more of the time, the majority of the times, the eviction is effective. Here you have the process of the communication, and okay, we are speaking about 2 years, 2 years and a half, and you can see the process is a process with the possibility to send documentation, to send information about the author, about the country, and always the committee send the different information from the parties to the other party. And then when the decision is published, the country has 6 months for the implementation of the recommendation, and the country has the obligation to send information about that, and the committee send this information from the country to the author for the contrast. What happens if the convicted state does not implement the recommendation? And is in general, not in all the recommendation with this 4 decision, but the majority of the recommendation does not implement at the moment. We have, in Spain, we have 2 ways. About recommendation in respect of the authors, we have in Spain a civil process, and the name is Victims Claim for Patrimonial Loss. And for the general recommendation about public policies and regulations, we have the other tools, the other international human rights international tools, the UPR and the ICESCR periodic reports. And for us, it's very important to remember all the times with all of us reporters to the United Nations, to the different committees, to the different possibilities, for example, the UPR and other spaces with the Human Rights Council, to send what happened in Spain with the general recommendation and what happened in Spain with the recommendation in respect of the authors. Finally, it's very important to remember that the optional protocol to the International Covenant on Economic, Social and Cultural Rights only has 7 years old, only 7 years old. And I said to you, and I said in my mind, there is still a lot to do. So, and we have time and we have the tools to start it to be reality. And thank you so much for your attention.
Thank you, Sonia. I haven't seen any questions asked in the chat. Like we have at least 10 more minutes before we finish. Maybe I will go back to my email because someone sent to me a question yesterday. Let me just. Well, just to say that, of course.
Maria Jose, one second. I forget to say that another tool is, of course, the reports of the special procedure and the special reporter of adequate housing, and also we use a lot this report to remember to the Spanish government what happened with the recommendation of the committee. So sorry because I forget that. So sorry.
Okay, thank you. No problem. It doesn't say who is this question for. I guess it may be good for Aoife because it's about the UK, I think, or no, maybe the UK, probably Ireland. How can we ensure the application of an equality framework in housing allocations if the system is riddled with discretionary practice and a lack of transparency? Do you think you can ask that? Yeah. You can answer that.
I can give an opinion on that from an advocacy perspective. From a European Social Charter perspective, obviously that's hugely problematic. As you know, the Irish system has been criticised in the past by the committee. I know that there's other organisations, including, I'm sure, the one that the person who's sending the question from is working on this. And I mean, it's a combination of, raising it again and again at a political level. With regards to if the feeling is that that is something that, for instance, the European Committee has not picked up on enough in its discussion of Ireland, and you could take a look at the 29 conclusions and you could see if you felt that that was the case, then I think it's a case of making that information known to the committee. And the reason, or potentially bringing a collective complaint. And as I've said in the chat, and certainly I think Maria is happy to do this, I'll circulate my slides and they include information about guides and about different approaches. But what I would say is that if you have a particular problem in a domestic context, you need to see first of all, how it fits within the Charter, and certainly that sounds like something that would fit within the Charter in terms of Article 16 or, Article 31. And depending on what the state has accepted, and then you need to see whether or not the best idea is whether it has been dealt with by the committee before, and if it hasn't been dealt with by the committee before, then it's about bringing it to the committee's attention. And I think it's worth noting that the committee, I've talked today about our collective complaints mechanism, but there's possibilities for third parties to intervene in collective complaints, but crucially, there's a possibility for civil society, for national human rights institutions, for trade unions in particular, to provide a response to the state report to the committee about how it's given effect to specific provisions. So for instance, the state gives its report, there's then a period when that is public, during which information can be submitted to the committee in response to the state report. Then the state gets to respond again. But so there are opportunities to feed into the reporting system, which means that if there's an issue like, for instance, issues around a highly problematic housing system with lots of discretionary payments in a particular country, that is the way to do it, and that can actually be less effort, demand less effort than a collective complaint. That said, we aren't looking at housing again for another 4 years, So 3 years. So in fact, maybe a collective complaint is another way of looking. And there's a lot of great groups that have brought complaints like that in Ireland. Irish Travelling Movement's been involved. Karen has done fantastic work. So I think that certainly there's scope in the Irish context, certainly of bringing a collective complaint. And the issue that you raise, while obviously I can't speak on the content, there has to be an effective, efficient housing system in place in states parties for them to be in compliance with the Charter.
Thank you, Aoife. There's another question by Michael Voss. For those who don't know him, he's a professor at the University of Nottingham. I don't know if I pronounced it well. He'd like to ask a question, I think it's for Sonia. He says it's great that we have a number of cases in Spain, but partly because of the cases, the Dutch government now refuses to ratify the optional protocol. So what are your thoughts on that? Like, is this the danger?
Yesterday, we had a meeting with the monitoring group, and we spoke about what happened now, because there are many cases from Spain in the committee, and also the committee is collapsed. Has been collapsed. I don't know if it's correct in English, and in one hand, this is a big problem. What happened with hundreds and hundreds of cases? Because in Spain, we are at the same moment that 2 years ago, with some small change in the law. And in the other hand, what happened with the countries? Because now countries in South America and countries in Europe are thinking to sign the optional protocol. Are you crazy? And tomorrow to have 2,000 of cases about housing, about health, about employment, about blah, blah, blah. But it's the power of the human rights, and the NGOs thinks about people, not about government. So for us, it's very important that everybody has the opportunity to go to the United Nations to say this has happened and this is a problem. So we understand that for other countries, the actual situation is I don't know in English. It's a big problem to sign the covenant. To sign the optional protocol of the covenant. But in the end, the question is if the people can go to the United Nations or not. And for us, the answer is so sorry. Petition, the Department of Petition in the committee in Geneva, they have many work, they have a lot of work, and so sorry for the rest of the countries. But we work for the people, not for the countries. So we know, but we understand, but this is the answer.
We don't have. Sorry.
I just wanted to come in very quickly on the ratification thing, because that's a huge issue for us. Because of course, the countries that have ratified the collective complaints have had complaints brought against them, and there you're dealing with a situation where the same challenge that you face with the UN, with the optional protocol to OP-ICESCR, is the same one you're going to have with the additional protocol to the European Social Charter. There is reluctance when it comes to international accountability, and states don't like being named and shamed, so they avoid it. But that's about advocacy. It's about engaging with your Department of Foreign Affairs, your Department of Justice. I mean, in many instances, it seems to be through personal relationships and building up civil society, Department of Justice, Department of Foreign Affairs links through which these things get moved forward. But that's going to depend on the country. I wanted to just very quickly flag as well, there's a question about non-state actors and corporate. May I respond to that, Maria? We're a state complaint system, just like the UN. So whereas we will deal with state failures to control or manage or prevent problematic behavior or rights harming behavior by non-state actors or corporate actors, you can't bring a complaint directly against them. But I know that Sonia will speak now about the obligation to protect and the UN committee's approach. we don't use the language of the obligation to protect, to prevent interference by third parties or non-state actors, but we're obviously aware of that. But ultimately we engage with the state, and it's about the state controlling non-state actors or preventing or remedying their activities. It's not about us directly saying, oh, well, such and such a company is at fault, such and such a landlord is at fault, they're in violation.
I'm just quite conscious of the time. I think we have consumed the hour that, well, nearly. Maybe we have time for one more question. I can't see them. Can you give examples of decisions where the committee concludes that there was no violation of the right to housing? I don't think
no, because no, sorry.
I was wondering which committee you meant, but Sonia, you take that, please. Yeah.
No. And no, and there are many not admission, not many, but there are not admission, and there are people who find a house, a public house, and desist of the decision. But there, I'm not sure. Okay, maybe I remember now that in one case they said that the right to housing has been not violated, but I'm not sure. Maybe one, but it's not usual. It's not usual because now and the communication need to have many documentation and you need to prove the situation. So, and I am thinking the last Friday I sent a new communication to the committee with 25 documents, judicial documents and public documents, and with and the communication had 20 pages. So, and the normal thing is that the committee said yes, you have the reason. It's not usual the other situation.
Well, unfortunately, these 1 hour webinars are not easy to handle. Let me just, I'm going to finish here. I see there are a few messages more in the chat. I am sorry for those who didn't get an answer to the questions. I hope that you will be able to find some of the questions or the answers here, but this is just the basic document that we would like our FEANTSA members and NGOs to use as much as possible. We should not underestimate either how relevant the EU may be in strengthening the right to housing, although today we didn't talk much about it. Although housing is not an EU competence, European institutions must protect also housing rights. I'm thinking of the EU Charter of Fundamental Rights, but I am thinking also about the economic and financial governance institutions of the EU, which view housing entirely as a financial asset. Many activists will agree with me that the issue of fighting financialization is huge in Europe, and many questions still remain unsolved, and we think that the law can have a role to play in that. For example, the impact on affordability of housing of platforms like Airbnb. How can cities control the prices in the affordability in their cities, things like that. And with these words, I would like to say bye. I would like to say thank you for being here. Thank you to both our speakers. Let's hope that we will be able to do some more webinars and some more training. I see there's need and there's a lot of appetite for that. So, well, maybe till the next time. Okay, thank you so much. Bye.
Thank you, Maria.
Bye-bye. Bye-bye. Thank you, Maria. Bye-bye.
Bye.